versus Ron DeSantis as governor et al. That's case 20 CA 1450. And Monique Belfleur et al. Versus Ron DeSantis governor. That's case 20 CA 1467. I consolidated these cases yesterday. The Belfleur case was the later filed up here. It's a case out of Orange County, and I came to the conclusion after reviewing both complaints that the cases involved numerous issues of common issues of law or fact. So I've consolidated those cases. We've got this hearing set this morning. According to my notice of hearing, we're here on the plaintiff's renewed motion for expedited mediation, the plaintiff's expedited motion for temporary injunction, and the defendant's motion to dismiss the complaint. Are y'all ready for all three of these things to be handled this morning?
Your Honor, this is Ron Meyer on behalf of the plaintiffs. And let me first of all say that I'm joined in representing all plaintiffs by Kendall Coffey, Josephina Aquila, Scott Hyacinth from the Coffey Burlington Law Firm, Mark Richard and Lucia Pardo from Phillips Richard and Rinn, Miami, and Kimberly Mention, who is the General Counsel of the Florida Education Association on behalf of the FEA plaintiffs. Your Honor, because of the raging pandemic and the immediacy of the issues facing public schools in the state of Florida, we've asked the court to schedule today as a status conference to attempt to make a determination as to when these motions can be handled. Now, perhaps the motion for expedited mediation is something which Mr. Richards will address, which could be disposed of today. We didn't notice the motion to dismiss or the motion for temporary injunction to be considered today. Your Honor, we're prepared to proceed on whatever schedule the court wants to proceed on because of the criticality of time. We have school employees who are retiring, resigning, fearful for their lives about going into school. We have schools which began opening brick and mortar facilities this past Monday, and they're going to continue on a rolling basis between now and the end of August to open in manners which frankly don't comport with the medical guidance provided by the CDC and other medical experts, and which the plaintiffs allege are putting people at risk. And of course, that raises the very constitutional issues that we have brought to the court, and that is that we have Article 9, Section 1A, which says it's the paramount duty of the state of Florida to provide a safe and secure system of free public schools. And then we have Article 9, Section 4B, that says it's up to the elected school boards to operate, control, and supervise schools. And that's been even codified in statute in Section 101.42, which gives school boards the right to determine the starting dates of schools and provides only that they can't start them before August 10th, but it leaves to the school board the determination of when schools should open. What has happened here, Your Honor, is the Commissioner of Education, through his emergency order, has just basically stepped across all of those constitutional lines and mandated that schools must open in August of this year in brick and mortar fashion. And we are faced with the real dilemma of it not being safe to do so, and that school boards, which have made decisions in some instances as to whether they are ready and able safely to open public schools, are being basically threatened with loss of funding and other pressure from the state not to do so, notwithstanding that it's a local school board decision. So we're faced with serious, imminent, irreparable injury, but we believe that the temporary injunction hearing will probably require the better part of a day, Your Honor, for the evidence that we have to put in.
Will require how much time?
I believe it'll take a day.
Your Honor, if I may, this is Jacob Stewart on behalf of plaintiffs Monique Belfleur and Catherine Hammond. We've spoken to the other plaintiffs' counsel yesterday for purely scheduling issues, and we concur. We believe that we would need, 8 hours for the full hearing to hear both cases simultaneously, Judge.
Well, let me hear who's speaking for the defense this morning.
Your Honor, David Wells of Gunster Yoakley. With me is Nathan Hill, my partner. We're the outside counsel for all of the state defendants, including Governor DeSantis and Commissioner Corcoran. We agree that this is a scheduling conference to try to decide how to move forward most appropriately. The case is a most unusual case. It asks the court to do, we think, things that are most impossible. It asks you to act as the governor of the state of Florida and rewrite Emergency Order 6, which has been propounded pursuant to his emergency orders and delegated to the commissioner, and ask you to close all 4,000 schools to in-person learning. They ask you to invalidate the choice of the parents of 1.6 million children who've asked to be able to be taught face-to-face in an atmosphere when it's undisputed that all students receive less from virtual education, and it's undisputed that the disadvantaged because they're English language learners, because they have individual educational plans, because they come from unsafe homes, are visited even more with the problems of virtual education. And then they ask you to act again as the governor and, using his emergency power, waive the Florida educational statutes and say, even though all the schools will be closed, they should be funded as if they're open. And then finally to step in as act as the superintendents for 67 separate counties and decide when these 4,000 schools will be open pursuant to some type of showing. And effectively, they're taking the Article 9 and turning it on its head and depriving parents and children of their constitutional right to a high quality education under Article 9. Under Article 9 says that the paramount goal is a high quality education, and in that you have to take into consideration, obviously, safety. What plaintiffs ask you to do here is step in and answer a political question, one that's a debate raging across the country with talking heads on both sides and mounds of data on both sides. We believe that it'll be shown that this is a political question that Your Honor can't answer, that in fact, what's going on with respect to Emergency Order 6 is it answers that political question, and acting as the executives are supposed to do, attempts to balance safety and balance the right to high quality education by, number one, allowing parents to have the choice to be there or not, have the children to be there or not be there. By number two, allowing additional funding that would not be there in response to a request from the superintendents. What happens if parents choose not to be there? Will we have less funding? What are we going to do? By providing the statutory waiver, the superintendents can offer multiple options to the parents, and they've done that, to be there with their students in person, to be there remote from the classroom, or to be there through a virtual high school. And it's that right of choice that the Plaintiff Teachers Union and these individual plaintiffs want to say no to. We think that the motion to dismiss raises serious threshold issues of the ability to seek that relief in court and have the court be the venue for that resolution. And we believe that what has to happen first is a hearing on this motion to dismiss to decide those threshold issues before going forward with the injunction or preparing on how we're going to do the injunction. I've yet to hear whether they propose to have live testimony or not. If so, how many witnesses, so that we could respond in terms of, is it a day, is it more than a day, or when should it be? So we believe that it would be appropriate to, number one, require the defendants to respond to our motion to dismiss. We've been promised one as soon as the court gave a number for the case, and have yet to see it to be able to prepare for that, or to have the court have the opportunity to review it. So we believe that what makes sense here is for that motion to be finally briefed by the plaintiffs, to be able to set a hearing and deal with those serious threshold issues. And then we should go ahead and plan an appropriate time for an injunction sometime after that, but at least with some consideration as to what the plaintiffs propose to do, so we can have some meaningful input as to how long it will take.
Mr. Meyer.
Your Honor, there's been a response filed to the motion to dismiss. I'm not sure why the council didn't receive it, but it's part of the court record. Your Honor, we don't have time to dally here. It's critical that these constitutional issues be resolved. The state is trying to make this about separation of powers, who gets to do what. All we have said, Your Honor, is the people of Florida have spoken that they demand as a paramount duty a safe environment for public schools. The people of Florida have spoken in the Constitution that local school boards should make those decisions informed by the best advice that they can get. That power has been taken away by the emergency order, and we believe the emergency order is an overreach and it's unconstitutional and should be set aside. That's all we're asking. If it's set aside, then local school boards will once again have the authority, unfettered by these arbitrary and capricious and ever-changing standards that the state wants to impose, to decide when and if it's the best time to open brick and mortar schools in a manner that doesn't put either the children, the staff, or the community at risk. Your Honor, there can be no doubt that just rushing to open public schools here in Florida, brick and mortar, is going to create the same kind of mess that we're seeing across the country, where you open them and then you end up closing them because there's COVID transmission being identified. We submit to you that the medical advice, the CDC, the State Department of Health, which by the way has been basically told not to get involved, and other medical experts who have looked at this should be consulted, and local school boards should make decisions based upon what is best for their particular school districts. And where they've attempted to do so, the state has come in and said, no, we're not going to pay for that. I find it kind of strange that in the spring, when this pandemic was barely unfolding and we were talking about very limited and low transmission rates and very limited and low instances of COVID infection, the state absolutely saw fit to continue funding distant learning opportunities through the public schools of this state in a manner that didn't diminish funding, didn't put children at risk, didn't put staff at risk, but in fact carried out the obligation to provide a quality education through distant learning opportunities. Now, while this virus is roiling through the state, we are Wuhan as far as the rest of the world is concerned. We're going to make a political judgment, apparently, at the state level to rush to open schools. Damn the torpedoes. Who cares whether it's safe or not? And that's just simply not right, and it's not constitutional. School boards elected by the people in a local community should be given the unfettered opportunity to make decisions with respect to whether it's safe and timely to open brick and mortar schools. Look, we all want to go back to school. All of the teachers in this state are wanting to go back to school, but they're not dying to go back to school. And that's what they're confronted with. Your Honor, just as we're all here on a Zoom hearing, because it's not safe for us to gather in a courtroom, why would it be any more safe for us to expect our teaching staff, our custodians, our bus drivers to present to public schools for 7-hour days in classes of 25 or 30 children and not expect to be putting them at risk? There may be some places where some structures can be fashioned, where some scheduling can be done, where some standards can be imposed consistent with good, sound health advice. But that's not what this executive order does. What this executive order, this emergency order that the commissioner put in place, it simply takes away the constitutional rights of elected local school boards and supplants it with the commissioner's ever-changing standard with respect to when you can, when you should, when you must open a school. And what we're faced with is an emergency order that says by the end of August, all schools all districts have to be offering brick and mortar schools. Your Honor, that's just not a safe thing to do, and we're prepared to demonstrate that in our injunction hearing.
Mr. Wells raises a good point. And that is, he says I should hear the motion to dismiss before we go forward with any temporary injunction hearing. I reviewed the plaintiff's response that was filed. As according to my docket, it was filed last Friday. So you should have that, Mr. Wells. But how long do you think it will take y'all to argue the motion to dismiss?
Your Honor, I think since we have the consolidated cases now with Mr. Stewart's case from Orlando, I would think we would need at least an hour and a half, 2 hours to thoroughly vet that.
What about Mr. Stewart, Mr. Whelan? You agree with that?
Yes, sir, we do.
And Mr. Wells, you agree with that?
Your Honor, I think 2 hours or more, depending on how the plaintiffs speak and how long each of them speak, would be appropriate to try to deal with these issues.
Well, I had a hearing that canceled this afternoon. Can y'all start back at 12:30 today on the motion to dismiss?
Yes, Your Honor.
We would request more time, Your Honor. There's certain things we need to prepare for. Mr. Wells indicated that, which we had never intended or promised, not sure it was indicated too, that he wanted a written response with legal, reasoning from us. And we're not prepared at this time to address that, Your Honor. We need a little more time.
Your Honor, I'd ask that you at least move it off to next Monday. And I apologize if we did not get that, but I did not receive it. And I guess because we had not yet had an appearance in the Tallahassee action, for whatever reason, it did not get to us by the e-portal. So,
well, let's say, just hypothetically, and I'm not saying how I'm going to rule on that motion to dismiss, but let's say that I deny the motion to dismiss. How quickly can y'all be ready to go on the temporary injunction hearing?
We would request that we would have to be ready to go before August 21st, Your Honor, because that date specifically in Orange County and Central Florida is when teachers are being required to report back in for in-person teaching. So if you're going to bifurcate the hearings, we would ask that the motion for temporary relief would be before the 21st, Your Honor.
And Your Honor, we certainly agree with the need to get that temporary injunction hearing conducted as soon next week as is practical, recognizing that the court probably has other things to do from time to time. But as time passes, more and more districts are going to be forced into reopening and are scheduled to reopen in manners which are going to frankly create health problems. So I would ask if the court could possibly see fit to conduct the injunction hearing on Tuesday or Wednesday of next week. That would be certainly ideal.
Mr. Stewart, you don't think you can be ready on the motions to dismiss tomorrow?
I mean, if we need to be, yes, Your Honor. Obviously, this is the pressing matter. So if that needs to be required by us, then I just don't think we can have a formal response in writing to be up to the level that required. But we certainly can be ready for oral arguments.
Well, it's not uncommon that I hear motions to dismiss without a written response from the plaintiff. But if you think you need more time than that, I'll certainly give you more time.
I'd ask for more time, Your Honor, and also to make sure that we're not duplicating argument by plaintiffs. We've just been aligned with the other plaintiffs, Your Honor, and I've begun to have formal conversations with them. So if Your Honor is inclined, as Mr. Myers suggested, if we were allowed to have the motion to dismiss on Monday, and then if you were hypothetically not to grant it, if we could have the motion for injunctive relief on Tuesday or Wednesday, that would present us with the ability to achieve what our suit is seeking to do.
Mr. Wells, I know you don't really have a real firm idea as to, I'm assuming you don't, as to who the plaintiffs will call as witnesses and all that. How long do you think it'll take for you to present your case?
Your Honor, I think part of it would depend on what they're doing. I do have some idea of what Mr. Stewart was going to do. We'll frankly have some objection to part of what he's trying to do in terms of his witnesses, but I have no idea what Mr. Meyer and his side
plan to do? Are they planning to call live witnesses? If so, how many and who? Those are the kinds of things that I think in all fairness, we ought to have the ability to prepare for. We certainly can be ready to go towards the end of next week, assuming we have that information in real time.
And Your Honor, that sort of leads me into the suggestion that's also before the court, and that was the plaintiff's renewed effort to bring this matter together for mediation. So not only can we resolve some of these issues associated with the course of this litigation, but ideally we could bring the parties to the table in a manner that would resolve some of these issues, maybe all of them. To date, there hasn't been a lot of conversation back and forth, and that's not directed at my colleagues representing the defendant. We just became engaged with them, but the point here is, Your Honor, if ever there was a time when it made sense to have people in a formal setting try to resolve issues, this is the time. We're faced with serious imminent injury. And we believe that there's room to reach some sort of logical accord as to how this can work in everybody's best interest. But right now, it's just not happening. And school districts are in a quandary, superintendents are in a quandary, and the state seems to be all over the place in terms of what it expects out of reopening brick and mortar schools. And perhaps Mr. Richard could better address what he feels that mediation might bring.
Well, let me just ask you this. I mean, I firmly believe that when the parties get together and come up with an agreed resolution of issues, it's many times and maybe most of the time better than what any court can come up with. But I don't, given this time schedule, how would y'all get a mediation in between now and if we have a motion to dismiss hearing for 2 hours, if we have a day or two of a temporary injunction hearing by the end of next week, I don't see how you have time to mediate the case.
Well, Your Honor, it's going to be a challenge because, time is not our friend here, but we're committed to working whenever, wherever, however, to try to resolve these issues if that's a possibility.
Well, I would love to see y'all mediate this case, but under this time frame, I can't order mediation on this. I think y'all are going to be real busy. If I go forward with an injunction hearing, y'all are going to be real busy getting ready for that. So I would love to order a mediation, but I don't think under this time frame that I can do it. So I'm going to deny the request for expedited mediation.
If I could be heard, Your Honor,
Yes,
it's Mark Richard on behalf of all the plaintiffs, and we're counsel to many of these unions across the state and the teachers and staff. We hear you. I would argue or ask the court to please consider that both sides have ample number of counsel. Mr. Wells' firm is a well-known, large firm that's got nationwide presence. We have the backing and support of our national unions. We have more than enough staff. And given the fact that there are no do-overs here, that whatever decision is made by the court, and hopefully it's to give the 67 districts a chance to make the decision without the threat of losing money. These districts are faced between being told it's their decision, but then being told on the same hand, go to local health authorities who have been instructed not to give them any direction. They're being told if they believe to open or not open, but if they don't actually open something brick and mortar 5 days a week, they're going to lose funding when they need more funding than ever to put up partitions in schools. Plexi.
Now, Mr. Richard, you're telling me things that, I mean, I would love to see it mediated. What you're saying, I guess, is that
we're willing to,
while we're doing all the other stuff, that other lawyers can be mediating the case. Do you agree with that, Mr. Wells?
No, Your Honor. I mean, for several reasons. First of all, there's serious threshold issues here as to whether this case should even be here. The commissioner, the Department of Education, has listened to all the stakeholders. The union's voice has been heard and it's been appreciated.
No, I'm just asking. I'm just asking from a person power standpoint. Do you have someone else that can be mediating the case for the defendants while I'm going forward on the legal issues.
Not on the schedule that we have that we're talking about here, Your Honor.
What does that mean? I'm not sure what that means.
I mean, the schedule you're talking about in terms of the motion to dismiss coming up and getting ready for the injunction hearing.
Well, but I think what Mr. Richards saying is that we've got enough lawyers on this case on both sides to where there can be lawyers getting ready for motions to dismiss and injunction hearings while other lawyers are getting ready and conducting mediation. Are you saying that you and Mr. Hill are the only ones that could do a mediation?
Goodness, no, Your Honor, I'm not suggesting that. Suggesting in terms of the people that are prepared to do that. And I'm also suggesting that simply by filing a lawsuit that we think they don't have really a basis to be able to do constitutionally, they don't get to elevate themselves into a bully pulpit and say that we have to sit down and listen to just their voice as opposed to the other voices that are out there. And we've heard no suggestion, we've heard no proposal. Before today, all we heard was we want an injunction requiring every single one of these schools to close now. Not give it to the superintendents, but to close now. And so, Your Honor, if they've got something to say, we're happy to listen to it, but to require us to sit down and go through a formal mediation, which at least in my experience can go from 15 minutes to 20 hours in the midst of this, I just don't think is something that makes any sense.
And Your Honor, on behalf of the plaintiffs who aren't part of the union, while we have similar common legal issues, I think Mr. Wells is, we just differ on our opinions on what the complaint or the purpose of this is. Our goal, Your Honor, is to allow each of 67 of the 67 counties in the state of Florida to make their decision on when they should be allowed to open and not lose funding. And that's simply it. And to protect teachers, students, bus drivers, which has been mentioned before, there is no purpose or alignment that we're trying to close schools forever. As already been indicated by other counsel, everyone wants schools to open. The question is the timing and when that is permitted by science, Your Honor. And that's been pled in our motions and pleadings.
Your Honor, just to be clear.
One last thing, I'm sorry, Ron. On the mediation, Your Honor, I think all the parties, including the court, bring up legitimate issues. But if there was ever a case to try, this would be it. If failure is what happens and we reach an impasse, so be it. But given the gravity that there are no do-overs, I would rather try, whether it's 15 minutes or longer, split up our firm, whether it's in the evening, whether it's with a formal mediation or informal. There is nothing wrong. We teach our students never to give up. We're not going to give up. And what we can simultaneously prepare, and as citizens of the world, and in being ravaged by this virus, which never takes a moment off, I think we can crowd our schedules and try to see if there's any way to resolve this.
Let me grab my calendar. I'll be right back. Okay, I've changed my mind on mediation. When Mr. Wells said that other people could do it, just didn't think it was a proper case for mediation. Here's what we're going to do. I'm going to set the hearing on the motion to dismiss for 1.5 hours, starting tomorrow at 11 a.m. So that's August 14 at 11 a.m. I'm going to and again, this is anything else I schedule is purely hypothetical, because if I grant the motion to dismiss, everything will come to a temporary halt anyway. I'm going to require mediation on Tuesday, August 18. Deadline for completing the mediation being midnight, Tuesday, August 18. So if you can start it Monday, great. but I want you to start it no later than 9 a.m. on August 18 and finish it by midnight, August 18. I'm going to clear 2 days on my calendar, Wednesday, August 19 and Thursday, August 20, for a potential injunction hearing. So we'll do the motion to dismiss tomorrow, starting at 11. Finish your mediation by midnight, August 18, and start the injunction hearing, if there's going to be one, at 8:30 a.m. on Wednesday, August 19, and you'll have Wednesday and Thursday available for the injunction hearing if you need it.
Thank you, Your Honor. Can we get some at least guidance on witnesses or what the plaintiffs are preparing to do if we're going to be trying to prepare for a injunction hearing coming next Wednesday?
Mr. Meyer, Mr. Coffey.
Mr. Coffey will address our plans on the temporary injunction hearing.
Your Honor, thank you. Kendall Coffey, part of the plaintiff attorneys. We'll confer with Mr. Wells, sort of the traditional way, and discuss with him. We envision some live witnesses, not somewhere, I'm going to say between 3 to 5, and also the use of declarations. But I think if he and I have known each other a long time, I think as we talk things through, we can come up with a reasonably clear set of schedules for each other, and an idea of what witnesses he's going to be calling live, and an idea of what witnesses will be calling live. So the things like witnesses, documents, I'm pretty confident that we'll be able to work that out with opposing counsel.
You agree with that, Mr. Wells?
I was going to say, Kendall was kind as far as how long we've known each other. But yes, I think that we can probably have that discussion, which will, I would hope, start today.
Okay. So I will get out an order today memorializing this schedule, and I will see everyone back tomorrow at 11 for the hearing on the motions to dismiss. Anything further we need to take up today?
Nothing
Yes.
from the plaintiffs, Your Honor. Thank you very much.
Ron, one last thing, Your Honor. Do you want us to try to agree on a mediator? Does the court want to appoint one? We have names. Whatever we could do without a mediator, we're pretty sophisticated, but we would be open to anything with the court's pleasure.
Well, I want y'all to try to agree as usual. And if at the conclusion of the hearing tomorrow, the motion to dismiss, if I grant the motion to dismiss, there will be no mediation. If I deny the motion to dismiss, y'all let me know if you're having difficulty coming up with a mediator, and I'll help you with that.
Thank you, sir.
That's fine, Your Honor. But get us some names and we'll see about their availability next week. And if
we can't find someone, perhaps the court will know.
All right. Anything further today?
No, Your Honor.
Okay,
No, Your Honor.
court's adjourned.
Thank you, Your Honor.
Thank you all.